Watching the Law and Crime Network, Aaron Keller along with you for the afternoon. As usual here on Law and Crime, we're going to switch gears again and talk a little bit about what happened earlier today in the Holly Bobo murder case out of Tennessee. The second of two defendants who's facing charges in that case is on the clock for whether or not he'll accept some kind of a reduced sentence or a lesser charge in return for a plea agreement. In other words, saving the people the cost, the time, the energy, and the expense of a trial. Burton Staggs is a guest we turn to frequently here on the Law and Crime Network. He's a local news director for WOPC Radio, a local radio station near where this entire disappearance and the first trial happened in Tennessee. Burton, it's good to talk to you again.
It's good to be back with you guys, Aaron.
So we had another hearing today, and the judge basically has been giving both sides a warning for several days here. It started, as I understand, last week, where he said, look, there needs to be some traction in this case. You can't keep dragging your feet as to whether or not there's going to be an offer of a plea, an acceptance of a plea, anything like that. So I'm giving you a deadline. And my understanding is that the goalpost has changed a couple of times here over the last couple of days. Am I correct in that?
That is correct. The goalpost was Thursday, and then they said they had made some progress. They moved it to today. He sent them back out to negotiate for about an hour. When they came back, said they had made no progress. He set the, for lack of a better word, the drop dead date as of January 22nd of next year.
So really, January 22nd is, I guess, the official deadline at this point.
Yes, he said it would not go past that, and the defense for Dylan Adams actually asked about maybe could that date be fluid because he needed to file some motions, and the judge basically said no, it's January 22nd.
So what did you take from this?
That the judge really wants this case over. As he said several times, it's gone on long enough. He told the victim's family, told the defense, he told the prosecutor. He spoke directly to the defendant, and he said it's gone on long enough. Today, he spoke directly to the defendant again and told him, after this date, if you enter a plea, it will be to the top counts of the indictment as charged.
We do have a clip of the hearing. I want to play that again for those of our viewers who missed it the first time around earlier today. Let's listen to this. It's not terribly long. It's a few minutes, and we'll be back with you, Burton, in just a second.
You may be seated. Good morning. I met just a moment ago with the Chief Deputy Prosecutor in this case as well as attorney for the defendant, and I wanted to check the progress. They indicated to me that essentially no progress had occurred since last Thursday when we adjourned. I don't mind kicking the can down the road some, but there's, as I told you the other day, there's a time where that will end. I told the parties back there that I think they owe it to their respective, the people that respectively they represent. I'm going to recess till around 11 o'clock. And I think it's everybody's best interest at that time to see if we can enter a negotiated plea. I think that perhaps after today, some of the dynamics in this case might change that might make a plea more difficult rather than less difficult to achieve. So I would urge the parties to put their best foot forward today. Going to recess till 11 o'clock or shortly after to give you time to speak with your respective sides and see if we can reach agreement. I'm not asking people to sacrifice their personal beliefs, but as I told you the other day, this thing is long past the time when it should have been resolved. So we will recess until 11 o'clock or shortly thereafter.
All right. All right, please.
Please seated.
Come to order. Please be seated.
Your Honor, if I may, there's a few minutes, I haven't got through security yet.
I understand no resolution.
That's correct.
Yes, Your Honor.
All right, what I'm going to do, January 22nd, 11 o'clock a.m. I've got a small civil matter at 10 that day, but at 11 a.m., I will call this case up. At that time, the parties need to understand that if there's not a plea reached, that is your deadline. I will not accept a negotiated plea after that date. The only resolution that could occur would be a plea to the indictment or a denial process. But there will not be a plea to a reduced charge. Now, I'm looking at you when I say that, but you already understand. You've been practicing before this court for many years. I use scheduling deadlines in virtually every criminal case. Mr. Adams, you need to understand that if there's not a negotiated plea of guilty on January 22nd, that you're going to trial. In other words, the deal will not get any sweeter because I will not allow it to get any sweeter. So if you wish to enter a negotiated plea, you need to be in discussion with your attorney to determine what's in your best interest, but you need to understand that if it's not entered on that date, I'm prepared to try.
Your Honor, I need to bring up one issue, though, concerning that and also concerning the plea deadline. When we have a plea line of January the 22nd and we have motions that may be forthcoming that may be somewhat dispositive on certain issues that restrict us on the availability of using that for any type of plea negotiations. So I like to remind the court that we have not yet argued motions in this case. And
if you don't have it ready for resolution, I will set a motion date. But that's something that you as his attorney need to take into consideration. I've been on the bench 30 years. I've got a long track record. I'm going to guess that both parties can probably perceive, I think I'm known to follow the letter of the law. Both sides should know probably what the resolution of any motions will be. So you need to take that into consideration. There's no sense in us taking a day or two to hear motions when we're going to trial. So you need to take that into consideration in your plea discussion, make your client aware of that. Okay?
if we're going to trial, did you say, Your Honor?
I said there's no sense in taking up motions unless we're going to
Oh,
trial.
unless.
There's no sense in
Okay.
me wasting
I
a day or
understand.
two hearing motions if this matter should be submitted on a plea. And both sides, you've been living with this case for 3 years, both sides. You ought to know what you're going to do, and I'm through beating around the bush, okay? So you need to understand that is the plea cutoff. At that time, if you don't submit a plea, I'll give you a date for motions, but we're going to trial. Okay?
Thank you, Your Honor.
All right. Anything else from the state?
No, sir.
Anything else from the defendant?
No, Your Honor.
All right.
All right, please. Court is dismissed.
All right, we remain on the line with Burton Staggs, local news director for WOPC Radio. He attends many of these hearings. He knows the parties. He's on the ground there in Tennessee, near where Holly Bobo's disappearance occurred. The state's version of the story is that she was kidnapped, raped, and murdered. We heard a key witness in the first trial related to her death, kidnapping, and murder as alleged by the state. So, Burton, you were at this hearing today. We've got the first defendant's brother up on charges in this case now, and it sounds like the judge is just trying to get the parties to move here. Are they going to do a plea? Are they going to go to trial? Where is this thing going to go? That's the big question.
That definitely is a big question. It's clear he's trying to motivate them with parties. And I'd say right now we're about 50-50 where we're going to go to trial in next May or not.
So my big question that I have in my mind is, what's the state's offer? Because they've been alleged a heinous crime, absolutely heinous. There's a sympathetic victim, a well-known local family, okay? What kind of offer might the state even be considering here?
I think that's open to discussion, and I've heard anywhere from a low of 25 to a high of life, and somewhere of a middle ground around 40 years.
So, of course, obviously, but you know, the first defendant was convicted and almost wound up with the death penalty here. So why would his brother want to try to hang on here? The only thing I think of is maybe this brother is going to point the finger at the other brother who was already convicted and said, look, they got the guy who did the worst of it.
That seems to be the where he would go. If you think back to the original case, the star witness, Jason Autry, basically said that Dylan, the defendant in today's action, was standing in the door of the trailer when he arrived. He really didn't point much of a finger at Dylan Adams.
Truth, at the first hearing, we've got Terry Dykes, who was the original lead investigator in this case, filing an affidavit saying there's no way that the star witness's testimony in the first trial could even be true. And the judge threw that out and disregarded it completely. And of course, we know from the trial that he was taking the case because his fears, the way he was handling it. So I call it a fiasco, but it certainly got a lot of moving parts that we normally don't see in other cases.
It does. You mentioned Autry's testimony. Is it truthful? Part of Dylan Adams's testimony, or excuse me, confession, alleged confession, seems to discredit Autry's. That Bobo was kept alive for some amount of time, possibly. That's the things we're hearing. If so, if that's his confession, it certainly brings Autry's timeline into question.
You know, and where are we going to go in this, though? I mean, normally when there's a plea agreement of some sort or some kind of an offer from the state, so, you know, the state could go for the life in prison. Normally, if there's a plea agreement, usually the state gets something out of it. Usually the state gets testimony, but this brother didn't testify against his brother Zach, who was already tried here. So what would be the state's reason for doing a plea?
The one thing that I go back to is that the Bobo family, well, it's obvious they want justice. Part of it is they probably want closure. And a little known fact, and I think we've talked about it briefly before, is the remains of Holly Bobo are still being held for evidentiary value pending the outcome of these trials. Part of it may be, as Karen Bobo said after the first trial, that taking the death penalty off the table allowed her family to start healing. Maybe allowing a plea bargain here with no appellate rights could allow for a funeral and to continue that healing.
You know, that's an interesting side of this that I had not considered at all, but you're the guy on the ground who knows many of the key players here. One thing that did bother me about the hearing today, and I know that the judge sort of tempered it, but you know, he brought up that he wanted this process to move along, and it's why he put a deadline on it, because the victim's family has been waiting for this closure for about 3 years. And my first reaction, and look, I know trial watchers are probably going to blow up at me and email me 1,000,002 things, but the trial ultimately is about the defendant. It's not about the victim. And I know that sounds unsympathetic, But the question at the trial is whether the defendant is guilty of the crime charged. And of course, we feel horribly sorry for victims and victims' families who go through horrific situations like this. And over the many, many years as a journalist, I've gotten to know many crime victims' families, some of whom I have kept in touch with years and years and years after original crimes have happened. But the trial is all about the defendant's guilt. So for the judge to say in part that he's putting a deadline on things out of concern for the victim's family, at least in part, that sort of rubbed me a little bit the wrong way. Did you have a similar reaction, Burton, or not?
Well, I did, but one of the little things that was missed is when he looked at the defense and said, you guys need to work on a deal, and he looks at the prosecution and says you need to either do that or nolly this case. So he gave the prosecution the option to dismiss the charges. He did go back and forth, and that was missed a little bit.
So in other words, when you use the phrase light a fire here, it may have been a fire under both sides, not necessarily the defense.
Oh, absolutely. He was talking to both parties.
We know that the case has gone on forever, and, I think that there was some bit of a merit to what the defense said, though, because, look, we've still had evidence in this case turn up, what was it, as early as earlier this year? So
yes,
when you've got a
Memorial
case,
Day holiday ago.
yeah, when you've got a case like that where things are coming in, of course, then it slows the proceedings down, because then the defense has to get a chance to look at it. Well, first of all, the state has to test it. The state has to turn the evidence over to the defense, at least it's supposed to. And the process grinds along because so many things have been discovered long after the disappearance, long after the arrests. And every time something new pops up, which in this case it seems to happen, every 6 months, every 9 months, every 12 months, something new happens, it seems. That takes time for parties to consider, to strategize. Things make cases stronger, things make cases weaker for both sides, and so of course it slows the process down. And I realize, it did rub me a little bit the wrong way when the judge said we need to kick things forward in part for the victim's family, but he was also very clear, hey, look, if both sides are just very entrenched in their positions and they're not going to budge whatsoever here, then we'll take this to trial, and I'm not telling people to give up something that they firmly believe they need to do. He did make that very clear as well in the interest of fairness, and I think that we need to point that out too.
You're exactly correct. He did say that, and he tries to be fair. I mean, he can be very firm, and as we said, light the fire, but it goes both ways.
Burton, we also have a post-court press conference that my understanding is you were present for it. We are able to play it. It's brief, but let's listen to that now, and we'll be back in a second.
Where's Derek?
Everybody ready? Are you all wanting a deal?
I'm not willing to make that comment.
Okay.
Any comment on what happened in court today? The judge has just reset it till January the 22nd to see if the parties reach an agreement. And if there's not an agreement, as you heard him say, he won't accept a guilty plea after that date. He'll set motions, and then we'll go forward with the trial next summer.
How you feeling?
So good.
Sorry, go ahead.
Go ahead.
I was just saying, can you explain the process when lawyers go behind doors to make a deal? I mean, is there a back and forth? Are y'all coming to the table with ideas? Are both sides coming to the table?
Probably a little bit of all of that. I mean, certainly there's a conversation in any case. I'm not talking about this one in particular, but when you're negotiating a case, you certainly talk back and forth.
And can you clarify something that we were just talking about? Can a judge say after such and such a date there will be no deal? Because then if you guys post that they can do a deal, I mean, at that point, wouldn't that be grounds for an appeal or something like that? I mean, aren't dates fluid?
The judge calls the shots, and the judge can certainly set timelines and deadlines for the parties to accomplish different things. And what he said actually is there won't be a negotiated plea after that date. The defendant, or any defendant, not just talking about this case, can plead guilty as charged, open to the court, and he would set the sentencing.
Can you tell us how the Bobos are doing?
Can you tell us how this case is different than the Adams case?
I really can't. I can't, you guys know by now, I can't comment on the on the plea on the particulars of the case. Thank you all. Thank you. Merry Christmas.
Happy Christmas, Steve.
So that was the post-court hearing press conference in the Holly Bobo case. And Burton, I'm guessing you picked up on this as well. Prosecutors have to be extremely careful when it comes to the discussion of any possibility of a plea. It's in the rules of professional conduct that it's a danger area where prosecutors shouldn't go. And I noticed that Prosecutor Nichols right there was just saying, I can talk generally about the process, but I can't get into any specifics about this particular case. Did you take away from that she was really trying to protect the defendant's rights here?
Absolutely. She was very careful in what she said, and yes, to protect the defendant's rights.
Yeah, I mean, this is an area that the rules of professional conduct specifically lay out where prosecutors need to be very careful of going. Because look, if a prosecutor starts discussing the possibility of a plea, then it starts to paint the defendant as guilty, and legally the presumption of innocence has to attach prior to a jury verdict. So this is a really hard area for a prosecutor to discuss. I'm sort of surprised that she even agreed to speak a little bit, but she had to speak in extreme generalities. And really all she did is sort of repeat what the judge already said on the record, just said, hey, look, the judge wants us to talk, so we'll sit down and talk. That really just summarizes everything that she said.
Yes, that's the entire press conference is basically just rehashing what was in court and the process, and the attorneys talk back and forth, but that's it.
Yeah, exactly. Is there anything else that happened today, Burton, that you observed that we weren't able to pick up on from watching here from a distance?
No, both families were in attendance. It is somewhat rare for the defendant's family to be in the courtroom, but they were in the courtroom, and we had a brief conversation, and she told me they were there to support Dylan Adams, and they were behind him 100%, and they supported him. That was about it. We just, as we've talked about, we're looking for that next date, and now it looks like it'll be January 22nd.
Yeah, we will certainly be watching. This has been a case with a lot of bumps in the road. It's certainly been interesting to watch, and we will continue to watch it. I know you will also continue to watch it. Burton Staggs, news director for a radio station in Tennessee, WOPC. We appreciate your insight here on the Law and Crime Network.
Thank you for having me, Aaron.
Okay, we'll catch you next time.